It's timely to do this. This really is at the forefront of our minds and really it's something that everybody on any board, commission, committee, any public agency has to think about this. So I'm going to start with sort of some of the basics, and then we could dig a little bit deeper. I think Nick will take us into some more detailed things and talk about electronic meetings, hybrid, et cetera, a little bit more about that stuff, and then we'll leave plenty of time, I think, for questions. So we're here talking about the Freedom of Information Act. The acronym we use is FOIA. That's what we're talking about. It is a state law. For anyone interested, it starts with Connecticut General Statutes 1-200, and then it goes for 41 sections after that. So it's a complicated law, and it's very nuanced. There's a lot of cases that have interpreted it, cases from the Freedom of Information Commission itself, cases from the courts, and that's how we generate our advice by reading the statute, then reading the decisions that have come out, and that forms the body of law here. It's the open government law in Connecticut, and I think every state has an open government law, somewhat similar to this, so it's not unique, but this is Connecticut's law. It basically covers two major areas that we deal with: access to records, public records, including emails and things of that nature. That's the first kind of broad area. The second area deals really with the conduct of meetings. And so those are kind of the two main sections that we talk about when we talk about FOIA. So the first question is, who's covered by this law? And on the one hand, it seems kind of easy. The easy part is, all of your normal boards and commissions, you can identify those in town council, P&Z, Board of Finance, wetlands, Board of Selectmen, and everything else that's set up under the charter. Those are all public agencies. You're all covered by this law. That's the easy part. Sometimes the trickier part is if there's like a specially appointed group, and that's where, for the most part, those are also public agencies. So, for instance, if the first select woman appoints, a special committee of citizens to make up a topic, the fields in town, recreational fields, to inventory and assess them or whatever. That's a public agency, and that committee, whatever you call it, doesn't matter if you call it, special committee, a working group, that doesn't particularly matter. But that group of people from the community appointed to do a certain task constitutes a public agency. So that comes up sometimes. On the other hand, and I think we'll loop back to this a little bit later, some things are not public agencies. So again, using the first select woman, she is a single member public agency. So when she meets with staff, a staff meeting, let's call them, and Tucker's there and Mimi's there and anyone else, Tiger, and pick your group of people who work for the town. That is not a public agency. So that's something that Deanna, you can do, and regular staff meetings are not public agencies. You don't have to abide by this. So that's kind of those are sort of the broad parameters. But most bodies that we encounter in the public arena, in the public sector, are public agencies, and they have to abide by the rules in terms of notice, in terms of certain conduct of meetings, in terms of minutes also, which have to be filed. We'll come back to that also. Subcommittees. This can be very tricky at times, but subcommittees are public agencies also, and are covered by this law. So again, an easy example is Board of Finance asks two people formally, officially, to investigate certain things, look into certain funds, health insurance or whatever, pick your topic. Those two people constitute a subcommittee. and they have to abide by these laws. And that's a formal subcommittee. Now, sometimes it's not quite that formal. And then it's kind of fact-based, and we can talk about that a little bit more, but the general rule is that subcommittees are covered by this law, and that's important to remember. That's different than one morning, one Board of Finance member gets up and calls another Board of Finance member and says, hey, Joe, do you want to, I got an idea, let's go down to town hall and we'll check on something or other. That's not a subcommittee. Typically, that's not a subcommittee. They weren't charged to do it. They're just doing it on their own initiative, and it's less than a quorum. So it does get nuanced. The quorum issue is important to consider also, and we'll talk a little bit more about that. Subcommittees are covered. So the next question, now that we've covered that, is what is a meeting? And I'm going to read the definition right from the law because I think that's illustrative of what we're getting at here. A meeting means a hearing or other proceeding, those are broad words, hearing or other proceeding of a public agency or assembly of a quorum. So you need to have a quorum, which is a majority of the members of a multi-member public agency. The quorum concept is important, and that usually is kind of a safe harbor. If you don't have a quorum, you're not having a meeting, and that's a rule we deal with and we abide by. So that's something to keep in mind also. The single member agency is what I talked about. In our world, that's generally the first select man or woman is considered a single member public agency. Kind of a different animal, and those kinds of staff meetings, as I mentioned, are perfectly fine without being subject to this law. Keep in mind that if a group, even a quorum of one public agency is in attendance, is present and in attendance at the meeting of another public agency, which has properly noticed their meeting, then that first agency that's there kind of observing is not subject to these laws. So what does that mean? It simply means, for example, members of the Board of Finance, even all of them, they can attend the town council meeting when the council is talking about the budget. They'll sit out here and it's not a meeting of the Board of Finance, it's a meeting of the town council. They're there to observe, maybe even comment, but it's not their meeting. So that's okay. That's not a meeting. Conference calls, emails, Zoom discussions can all and often do constitute meetings, and that's where we get tripped up sometimes. We'll talk about that, particularly the emails. Electronic communications can constitute emails, can constitute meetings. And that may be the single trickiest area here. How do we handle emails? Used to be we worried about phone calls. Doesn't happen quite as much now. I guess people do still talk to each other, but the emails can be the trickiest part of this, and we'll get back to that in just a minute. Also keep in mind in these communications, it has to be over something over which the board has responsibility, and sometimes that comes up. Board of Finance members might be talking about I don't know what, pick a topic that they have no response, land use decisions or something for some reason. That's not something over which they have responsibility, so that would take it out of the meeting context typically. So beware the electronic communications, and we're going to come back to talk about emails in particular. What is not a meeting? The statute itself, the law itself tells you what is not a meeting. So for our purposes, social gatherings are not a meeting. You get invited to someone's holiday party, the whole planning and zoning commission, that's okay. You can go. Shouldn't talk about business, shouldn't talk about applications, but you can certainly attend. Social gatherings are not meetings. Strategy or negotiations with respect to collective bargaining, that is not under the law considered a meeting, so it's exempt from this. Political caucuses. Members of one party, of the agency, can meet with each other, and that does not constitute a meeting. All the Democrats, all the Republicans, but there's some guidelines here. It has to be just the members of that agency. You can't start bringing in, the head of the party or someone else. That would not be considered a proper caucus. Just the members. And keep in mind also, it's important to say this. Some people think this is the answer to everything. It's the answer to FOIA. You can have a caucus of one political party, and it is not considered a meeting in violation of this law. But it may be violating something else. And the example I use is a real example, not from New Canaan, and not too recently, but it was a planning and zoning commission. And literally in the middle of a meeting, they took a break, and members of one party, they got up and they decided to caucus in the middle of an application from a private property owner. And they came back and they went back into the meeting, and then they voted, I think, to approve it. Okay, that's a caucus. That doesn't violate this law. It does, in my opinion, violate due process, because that property owner was entitled to hear that discussion in public regarding his or her land use rights. So you do have to be careful. There's a time and a place for a caucus, and that P&Z example is not a good time. And I would caution anybody in the land use business about political caucuses, because those kinds of discussions should be in public so that the property owner can hear what the concerns are and react and respond. It's a lot easier to do it on other policy type issues, finance, board selection, whatever. But that's the political caucus exception to the Freedom of Information Act, and you can certainly do that. Okay, emails. You can use email for some purposes. So certainly the chair can send out administrative type emails. Don't forget, we're meeting at 7:30 next Tuesday instead of 7 o'clock or whatever. That's easy enough. Somebody wants to write back and says, I can't make it till 7:45, that's okay too. Individuals less than a quorum technically can communicate with each other. So it doesn't violate the law for one person to pick up the phone or to write an email to one other person. But again, a caution there. I don't advocate that, because, as they say, the public's business should be done in public. But I know it happens, obviously, and it doesn't violate the law. What it does, however, we were just talking about this, Nick and I, today. What happens many times, not all the time, is that there'll be an email to one person, and then one person writes to another person, and all of a sudden you have back and forth, and there's a quorum emailing each other back and forth. That is an illegal meeting, because it hasn't been posted, the public can't hear it, so you can't do that. You've got to be very careful, and that's why we generally caution even about, even against one-on-one emails. You just have to be careful about it, because it can lead to a greater discussion. And you certainly can't plan this out and try to avoid the law by saying, well, I'll write to this person and you write to that person, you write to this person, and that way, the individual emails, that doesn't work either, because that's a meeting. So just be careful with the emails. It applies to phone calls too. It applies to texts also. The problem with text is that they're not always preserved. And it's probably not a great idea to use a lot of text. They're harder to, I think, to reproduce and all that. So emails are the big issue in every town, and nobody knows that better than Mimi, of course, in terms of the emails, because I think probably all of you get a town assigned email, which I think is good. You should use that exclusively for your town business. Don't mix and match with your own personal email address, because if you use your personal email address for town business, it's subject to a FOIA request. And then it'll be up to you to go through your own computer and sort out what was, your personal business versus town business. And it's time consuming. So
Ira, can I just jump in, not with a question, but just a point on that one? Not everybody does have a town email address.
okay.
So what we've advised some of our other committees, if you will, is to set up a separate email address that's just for that purpose.
Right.
My TDAC people have their tdac@gmail.com or whatever, so it's not commingled with their regular personal.
No, that's a good point. If you don't have a town one set up,
Yes, they get those, yeah.
yeah.
Yeah, these are picking everything up.
Cool.
Yeah, well, that's very important. If you don't have the town email address, then set up your own separate, Google type address. But you do want to isolate it. All right. So, and again, the topic has to be something over which your board has supervision, jurisdiction, control, not just some random topic. That's what we're talking about in this situation. So that's a start, at least over the emails. A couple other points, though. It is also allowed if one person, suppose there's a topic before a particular board, and one member of that board says, I'd like to let everyone know what I think about this upcoming topic, a purchase of a fire truck. So that board member could, I'm not sure it's the best idea or best way to do it, but that one board member could say, what, I'm going to send to all of my colleagues, the whole board, my thoughts on this. And he or she can do that. The meeting is created when people start responding. So if you're inclined to do that, if you feel compelled to let people know what you think, the best thing is at the bottom to say, here's what I think. I'm going to raise these points at the meeting next week. I just want you all to have a head start and start thinking about it. Please do not respond, because it's a response that creates the potential illegal meeting. You want to send something out, you can do that. It's probably best to also put it into the public record, either by reading it or somehow putting it in, and so it's available to the public if you're going to do that. But the recipients of that should not respond, because that creates the back and forth. It's not the first person sending it out, it's the person who responds that starts creating the meeting, and that's the problem. So again, be careful of that kind of thing too. We'll have plenty of other, I think, comments and or questions on public meeting, on emails. Again, I think we've made the point that if there's less than a quorum, that's not a meeting. So that's pretty easy to understand, and that comes up quite a bit. 3 members out of 7 is not a quorum, obviously. There is a problem, though, sometimes when you have less than a quorum. Again, back to the subcommittee issue. Is it a subcommittee? Has it been set up as a subcommittee? So you have to be a little careful, even if it's less than a quorum, because if it's a subcommittee, that in and of itself is a public agency subject to all these laws. So you have to be careful. Subcommittees are generally authorized, as I said before. Sometimes it's less than an express authorization, and just have to be careful that there is a fairly new case that we often cite from Meriden, which basically says if it's less than a quorum, then it's not a public agency, not subject to FOIA. That remains the law, but we have to be careful, in my opinion, of the subcommittee kind of issue. and whether the smaller group was authorized to do something expressly or impliedly. I'll leave it at that for now. Couple more things, and I'm going to turn this over to Nick. I guess I'll cover the types of meetings very quickly.
Sure.
It's only a couple minutes or less. There are three types of meetings under the law. There are regular meetings, special meetings, and emergency meetings. The regular meetings are set up before January 31, so I guess it should be now, of each year. And that's the list of meetings, dates for the year. And that generally does not change unless there's an emergency or, weather problem or something like that. So those are set out and those are regular meetings. And that carries a certain set of rules in terms of supplementing or adding to the agenda. So you can do that for a regular meeting. Besides regular meetings, there are special meetings. And those are not set up in January, but they come up from time to time. Those require 24 hours notice for a regular in-person meeting. We're going to talk about Zoom type meetings in a few minutes, but 24 hours notice basically for a regular, for a special meeting in person. There's a lot of those. And then there are emergency meetings, which fortunately don't occur too often. But when they do occur, often it's an emergency and hopefully it's just like a weather emergency. Where you just have to get together for some reason. The Board of Selectmen may have to get together to sign some contracts to get, more plows in town or something like that. And there's no time for 24 hours. So you just do it as a special meeting, and then there's certain requirements about filing the minutes thereafter within, I guess, 72 hours. So there are not a lot of those emergency meetings, fortunately. I think I'll take a pause here, let Nick pick up on some other topics, and we'll keep going.
I guess that's where you want us to be on the.
You know what, Mimi? Yes, that's perfect. Thank you. All right. Thanks, Ira. Good evening again, everyone. So as you just heard, Ira talked a little bit about what the act is, who it applies to, when it applies, i.e. when are we actually having meetings? But it also, the act sets certain procedural requirements that go along with these open meetings. It's these requirements that apply before open public meetings. There's some requirements that apply during the open public meetings. And then, like Ira just mentioned, there's some requirements that come after the meeting has concluded. So to make sure the public, so we'll start with before a meeting. And for some of you board members, this is going to be less important because you're not in control of putting the notice out or the agenda out. Someone from staff or perhaps a chairperson might be taking that role forward. So this might not be quite as relevant, but it's still worth mentioning and understanding how the public's supposed to be informed about these meetings and how they're able to access these meetings. So before meetings, to make sure that the public knows how to attend, when they are, and what's going to be discussed, the Act, FOIA, requires that the town provide, obviously, notice in advance. It's a big issue. We need notice of your public meetings. So the way that the Act does this, the way that the Act gives the public notice of these town meetings, these public board and commission meetings, is in two ways. It requires a meeting notice, and it also separately requires a meeting agenda. Now, sometimes those two, a notice and agenda, is the same document, but sometimes they're posted at different times. So I'm going to just briefly try to differentiate the two. So meeting notices are just that. They're a notification to the public that a town of New Canaan public agency will be holding a meeting at a certain time, place, and date. That's all it is. Agendas are the list of items that are going to be discussed at that meeting. So the public is informed ahead of time, okay, this is what's going to be discussed at the upcoming meeting. Now, the requirements under the act for when we as public agencies post notices and agendas depends on the type of meeting that we're talking about. Ira just described the 3 types of meetings under the act: regular meetings, special meetings, and emergency meetings. So, as Ira mentioned, emergency meetings don't really happen very often. So let's just think about notice and agendas in the context of regular meetings and then special meetings. So for regular meetings are just the meetings of the public agency that's set at the beginning of the year. January, the boards and commissions will establish a list for the rest of the year for when they're in their monthly meetings, bi-monthly, whatever they are. It's going to be a schedule of meetings for the year, and that gets posted with the town clerk. That is a notice of a regular meeting. For meetings that are held remotely, there's a little bit of a different requirement, and the notice has to include the link to a remote, a Zoom link or a video conferencing link. That, what the act says is that at least 48 hours in advance, that Zoom link has to be broadcast out to the public. So, for example, I just gave the example of a regular meeting. Those meetings are noticed at the beginning of the year with the schedule that's filed with the town clerk. But that schedule of the regular meetings isn't going to have every Zoom link. It's not going to have every agenda for each one of those meetings as they progress throughout the year. So then what we more typically see is the agendas under the act, agendas, the specific items have to be posted 24 hours before a meeting. At least 24 hours. Oftentimes our boards and commissions publish a week in advance, the best that we can, basically. But under the law, the agendas have to be set and publicized at least 24 hours in advance. And where there's a remote component, a Zoom component, that link has to be provided at least 48 hours in advance. Those are the two main time frames to keep in mind here. 24 hours. The only difference is when there's a Zoom component, you're looking at 48 hours advance notice. Okay, special meetings. Still on this slide, Mimi, thanks. We're almost at the next one. So the difference between special meetings and regular meetings. Special meetings are just meetings that are not those established at the beginning of the year, and they just come up during the year when there might be some sort of item that needs discussion, that needs quicker discussion, or people aren't able to make a regular meeting, so you want to set a new meeting. That's a special meeting. And similarly, I talked about the 24 hours timeline here. For special meetings, same requirements apply. The agenda would have to be 24 hours in advance. And similarly, for these special meetings, these ones that are scheduled during the year, if there's an electronic component, that too is a 24-hour advance notice. So the only time you're giving advanced 48-hour public notice is when there's a regular meeting, one of the ones set at the beginning of the year, that's going to have some sort of Zoom interface with the public. The rest of, whether it's a special meeting or otherwise an agenda for a regular meeting, that has to get noticed 24 hours in advance. So those are the
And
differences.
for what it's worth, to me, that's counterintuitive, that you have more notice for the regular meeting than for the special meeting. And I've gotten it confused, but that is what the law says.
It is. Okay, moving on. I know that's obviously we're throwing a lot of, pretty granular stuff at everyone. But this is the difficulty with FOIA. There's lots of moving pieces here. There's lots of things to keep in mind. So we try to give you in as broad strokes as we can, this presentation, our more thorough outline, but then really it's most helpful on a case-by-case basis when folks in positions such as yourselves have situations, you raise those with us and we try to figure it out together. All right, so moving on, can an agenda be changed after it's been posted to the public? The answer to that is yes, but only during the meeting itself. If 2/3 of the total members of that public agency vote to add the item to the agenda. So that would be legal under the act, even though it wasn't on the publicly noticed agenda. And for that reason, we don't recommend that practice. It is legal under the act to add something with a 2/3 vote during the meeting that was not otherwise listed on the public agenda.
Not a special meeting, right?
Correct, not a special meeting. That's right. Regular meetings only.
Can I say something about the content of the agenda, so if you're, that's gonna cover.
Yeah, sure.
This is a good time.
Yeah.
Okay, all right, good. Sorry, I just don't want to interrupt too many times, but a couple of things about agendas, the content of the agendas. The content ought to reasonably apprise the public of what the topic is. So, you need to use real words, real English, not what I've seen agendas that say, property discussion or something. What does that mean? To put down what you're discussing about. What's the address? If you intend to vote for something, or if you expect that there'll be a vote on a particular night, you need to put that in there. Discussion and vote, or what we like to say is discussion and potential vote for purchase of property at 7. Because there are cases where if you don't say possible vote and you end up voting, there are cases that say, well, you have not reasonably apprised the public of what's going on. They see you're discussing it. I don't want to hear any discussion. If they saw you're voting on it that night, they might come down. So that's one example. It's a real example. If you're going to vote, say discussion and vote, or better yet, potential vote, because you may not vote. And put sufficient description of what the topic is. So people can understand what it is and make a decision as to whether they want to attend the meeting or not. In addition, we discourage use of the terms other business. The last item, other business, or new business. What does that mean? What is someone who's at home and sees that agenda online supposed to think? Well, what are you talking about, other business? Like, tell me what you're talking about. What is that other business? So don't use those words. Spell it out. If it's on the agenda, you can add to the agenda, as we've discussed, but that's a different thing. If you're going to either put it on, we'll put it on. Let's leave it at that. So those are my comments about the content of the agendas.
Okay, we're gonna keep moving here. Maybe next slide, please. So we talked about before a meeting, what does the act require? Basically notices and agendas. So now let's talk about during the public meetings. What does the act say? So a few things here. Although members of the public do have the right to attend any public meeting, there's no general right to speak. Really, it's only where the agency has invited comment on a topic or voluntarily traditionally has a public comment opportunity on its meeting-to-meeting agenda, or if there's a statutory public hearing required. Those are when the public has a right to speak. Otherwise, there is not a baseline right of the public to speak at any public meeting on any topic that they choose. members of the public do have the right to record or broadcast public meetings. And if a member of the public creates a disturbance during the meeting, agency holding that meeting can remove him or her, or if the disturbance continues, the agency can clear the room and continue only with non-disturbing members of the media present. That rarely occurs, and there's different strategies if there's a very contentious item and there's a lot of talking and activity going on during the meeting, then there's ways to strategically take a break, take a recess, calm things down, and then regroup without having to really just remove everyone from the room or adjourn the meeting to a later date. But the act does give that authority if there really is that level of a disturbance.
And that is kind of a tried and true method for the chair. If somebody is truly disturbing the meeting and you ask the person, please, wait for your turn, please sit down, whatever, and the person won't do it, chair can bang the gavel and say, we're going to take a 10-minute break, just as Nick alluded to. Talk to the person, and if that doesn't work, then you either can adjourn, or in an extreme case, if someone is breaching the peace, disturbing the meeting, you can call the police. It is a limited public forum, so you can't say whatever you want at any time. Meetings. One other thing about disturbances, just to add some color to this. I've been in meetings, and this occurs across the country, where people have, worn T-shirts that supported something that's on the agenda. Yes, I support the purchase or whatever. And, you see a sea of, yellow shirts, and then go beyond that. People come in with big hats. Or what if they have flags or banners that they put at the back of the room saying, vote yes for the purchase, or whatever the topic is. At what point is that disruptive? And at what point is that a protected First Amendment right? Some of that's pretty obvious, I guess, simply wearing a shirt or something like that, even hats, whatever. Most of what I said as examples, I think, are protected by the First Amendment, but you can come up with your own examples, and that does occur in terms of, when is it disruptive and should be stopped? When is it protected speech?
Okay, thanks, Mimi. Next slide, please. Still on the topic of during, but now since after COVID, we're in the advent of the remote Zoom meeting world. So the act has also evolved to accommodate remote public meetings, or at least give the towns the option to offer remote public meetings to the general public. So for remote meetings, though, there's a couple additional strings attached under the act. So number one, the act gives agency members themselves the right to participate remotely, but there is no automatic right to the public to attend a public meeting remotely. That right under the act only falls to the meeting members. It's really at the town, at the agency's discretion to allow remote participation by the public. And what I mean by that is where there is a public comment item, or where there is a public hearing, and members of the public are going to be making comment. What that means is the town can allow for that back and forth video conference, that Zoom, to happen with the public, but the town can also say, this is just an in-person meeting. If members of the agency appear remotely, that doesn't now automatically open this up to a public meeting that it now must be made accessible to the rest of the public. There's a little bit of confusion over that one. But I mean, obviously in today's world, many municipalities, many public agencies are giving that hybrid option if people want to come in person, or if they also want to, at the very least, watch remotely, then that's typically an option that municipalities are giving to the public. Also for remote meetings, the votes are supposed to be roll call, since We might not know exactly who's talking. Similarly, remote participants are supposed to try to identify themselves verbally, even if their face is right there on the screen. And then just some common sense stuff, like we all have experienced connection issues, tech issues during these meetings. And so the act builds in some ability to the chairman and to the agencies to reconvene a little bit later or postpone even to a later date in the event of these technical glitches during a remote meeting. And similarly for remote meetings, a chairman or woman can call for removal of remote attendees who are causing disruption in order. Next slide, please, Mimi. All right, now's where it really starts getting confusing if it hasn't already. So there's another level of requirements that apply to regular meetings. So remember those ones that are set at the beginning of the year that are just completely remote. And these really applied back during COVID when every meeting was under the governor's executive orders required to be fully remote. But this technically still is in the act. So for these regular meetings, the ones set at the beginning of the year that there is no in-person component to, there's a handful of additional requirements, such as if a member of the public doesn't have a computer, how are they going to watch this fully remote public meeting? Well, the act says they can, within 24 hours prior to the meeting, ask the town to basically give them a computer and a location to participate in this meeting. Remote, fully, again, these are just for fully remote regular meetings. They have to be fully recorded and posted within 7 days. Now, this is a little bit of a modifier to what I said in the last slide, but again, this is a different situation where it's a fully remote regular meeting. And if a quorum, so if a majority of those agency members, if they say, okay, we've got this fully remote meeting, but we're all gonna, the agency members, it's gonna be easier for us to all use the same laptop. So we're all gonna hang out in the conference room for this fully remote meeting, but everyone else doesn't get to show up in person. Everyone else has to just go on their computer. The act says, no, you can't do that. If a quorum of the actual agency members show up somewhere to have the meeting, you got to let the public in too. And for these, again, fully remote, regular meetings, the public has to have the same opportunity to participate as if they were at an in-person meeting. So like I said before, if someone's going to be making a comment, they need to be able to make that comment on the Zoom conference for everyone else to hear. They need to be able to see what's been submitted in order to make an informed comment. So the act says these fully remote regular meetings have to be as close as possible to the real thing. All right.
Just a quick comment that there's no uniformity among towns or even within towns as to whether there should be in-person meetings or all remote or hybrid. I mean, you see all kinds, and that just adds to the confusion in terms of rules. You know, we see all kinds of meetings, those three, and it just, you know, you just got to keep track of everything carefully because the rules are different, notice, et cetera, et cetera. It's very, it allows for flexibility and it has certain advantages, I think, but it also can be very confusing.
What happens if it was originally a hybrid meeting and at the last minute, everybody said, I'm sick or the weather's bad, we're doing it fully remote? It wasn't noticed as a fully remote meeting. It was storms coming in, no one wants to drive, it's 5 o'clock, meeting at 7, you know, we're all gonna stay home. And now everybody's remote, even though it wasn't noticed as a remote meeting. That has happened a couple times.
What do you think?
How long in advance?
Like at 5 o'clock, all of a sudden the roads are lousy and everyone.
Oh, for a meeting that night?
Yeah, It's happened a couple times.
I was just gonna say, if there's a, an instance to have an I mean, an emergency meeting is more of like a catastrophic. There's a hurricane coming through town and we need to get, I don't know, the Parks and Rec Commission to get, the bad example, but something like that. I don't know, Tucker, you might,
Recently with some illness, there was a meeting and then at 5 o'clock, everyone said, you know what, I'm not feeling well. The next person, all of a sudden, I had nobody coming to the meeting.
I think you have to look at it. I mean, who would be disadvantaged or whose interest would be compromised? Is there
Unless
any-
somebody showed up here and there was no meeting because everybody was on the phone.
Yeah, well, that could be that someone drives through 6 inches of snow, gets to town hall and sees that it's closed.
right.
But I gotta believe if that ever went up to the commission, they would understand. I mean, people didn't want to drive. I don't know.
Well,
Well, I mean, if
maybe
it's,
not.
I don't know.
I mean, they might say, well, you should have anticipated that. There are some people that, insist on coming to meetings because it's a thing to do or whatever. And they got down here and by the time they got home and turned on their computer, it was too late. It might be over. So, I mean, that would be a risk, I guess.
But if you were here in the original location of the meeting, as long as you gave them access.
But I might not be here. I mean, it could be your meeting,
Well, if no one was here.
right? So if
then-
nobody showed up, that's.
I mean-
Now the meetings on every agenda, you post the hybrid link.
So I was just gonna say, our recommendation is that we always, we're going hybrid. Because what I found is that people have every intention of coming to the meeting and at the last minute, they don't feel well or a kid is sick or something happens. And it becomes, and you just want to have everyone have that hybrid option. I think it makes sense. I personally prefer in person because I think it's easier to get work done. But I do understand the benefits of the hybrid model and the remote access for people that are attending and just.
I think in that scenario that, that got canceled 5 o'clock, someone might show up, town hall's closed, lights are off. One practical solution is for the agency, like to keep the hearing open. So that one person, or maybe it's 6 people.
Have another opportunity.
Yeah, they can come to the next meeting and voice their comments. So that might be one.
By, one, put a note on the door, explain what happened, so they know when they arrive. And that we video record all meetings, so the public has access to review all meetings, at any point, and it's posted on it. So I mean, obviously you don't want it to become a habit, but would you benefit in a FOIA court from the fact that every single meeting that we have in this town is recorded and put on?
Well,
We don't have a, I mean,
Yeah,
at least
it-
what you
it could
said
help, but-
before, there's no duty to allow public comment or public input. It's just a nice practice.
unless it was something that did require like a public hearing before the P and Z.
Which I think a public hearing would be a very different situation than a normal meeting, but I think, I mean, my interpretation, and I am not a lawyer,
Yeah.
would be that because you're under no obligation to require or to allow public comment, that as long as you recorded and you put a note on the door in a weather situation.
Yeah, no, I think
That's
it,
what
yeah, if the person didn't have an opportunity to speak to begin with, and it was just a matter that they wanted to watch, then I think that might be sufficient. If it
But if
was-
you're right, public hearing, you'd always reschedule.
Yes. And leave it.
Yeah, if they have a right to speak and they come down here and, I mean, this is kind of a unlikely scenario, I think. But if it did happen, then either keep it open for another, if it was the P and Z, that's what I would say. I said, well, keep it open to the next meeting for those people who couldn't make it or something. Something like that.
What is the statute on terminating?
Canceling.
Yes,
Well, I mean, you can cancel a meeting,
well,
but
I realize we can
yeah.
cancel a meeting. but
Time.
Is there a time guideline that can't cancel the meeting 5 minutes before the meeting starts because of weather? Because of anything
well,
of that nature? Is there- I didn't see anything in here in terms of time commitment or time restrictions on cancellation of the meeting.
I separate the land use boards from everyone else, because then you're dealing with right to speak. It's, you know, it's a public hearing, not a public meeting. Public hearing means people have a right to speak. Public meeting means you're just meeting in public. So there's a distinction there. If it's a public meeting, I think you can legally cancel it because of some extraordinary situation. You run into the court of public opinion. If too many people show up, you know, and they see they can't get in the building, they're going to be angry. But no law has been violated. I mean, just today I had a situation where a lawyer called me. This is a wetlands commission, and they put out something that said meeting canceled tonight. And he was in the middle of a hearing for his client, you know, on a residential house. And the meeting meeting canceled didn't say when the next public hearing was for that wetlands commission. And that created some issues in terms of you know, public hearings in the land use situation. That's kind of a separate class. I won't bore you with all the details. You know, we had to sort of make arrangements on that, but I don't think there's any time element involved, except, you know, common sense and trying to be fair to the people who want to speak, who live in town, and not do it too late.
The only caveat that I would say to that is, I've also seen this happen where we had a meeting scheduled for 7 o'clock. And then we decided, you know what, 2 days before or a day before, we decided, you know what, actually, let's do it at 6 o'clock because it's going to be quite long. So we changed the time. That then converted it to a special meeting, correct? Yeah, so all of a sudden now it's a special meeting, so nothing can be added to the agenda, and you've got all those parameters that you have to oblige by for the special meeting.
But even that, how do you get the word out? You know,
Right.
someone looks at the legal notice in the paper, if anybody still does that, and they see it starts at 7, and now all of a sudden it's starting at 6. So what do you do? That's part of the problem. It's tricky.
Okay, a few more sections. I'm going to talk about the couple requirements after a public meeting has occurred. We're going to spend a short amount of time on executive sessions, which are the non-public portions of these agency meetings. And then we'll talk about the other category briefly of what the Act regulates. In addition to these open public meetings that we've been talking about for the past 55 minutes, it also deals with public records and when people make FOIA requests that all of you and your emails would be subject to in your town roles. So we'll just touch on that as well. So Mimi, next slide, please. After a public meeting has occurred, the Act has a handful of requirements. The first being if there was some formal vote that the agency who had the meeting, if there was a vote taken, within 48 hours, a record of that vote. It doesn't have to be the full minutes of the meeting, but just a record of who voted has to be available if a member of the public asks for it, that agency. And then within 7 days of the meeting, that's how long the agency has to put minutes together. And those minutes then are made available for the public as well. They do not have to be verbatim transcript minutes, but they do have to have some specificity of what transpired. So things like the time and place of the meeting, when it convened and when it adjourned, which members attended, how they voted, each action item and what happened, the purpose of any executive sessions, and which members participated remotely. So again, our outline gets a little bit more granular on that, but you know, this is where minutes come in. You're informing the public now who didn't get an opportunity to watch the meeting or watch a recording. They get to read these minutes, which summarizes what actually happened at the meeting.
Those are draft minutes.
That's right. And the draft minutes then would be ratified by that agency at the subsequent meeting. So the agency will typically at the end of their agenda say, okay, we're reviewing the minutes for last meetings, for the minutes for the last meeting. And there'll be a vote taken of the agency if that accurately reflects what happened. And then at that point, those minutes become the official minutes of that agency meeting.
Can I just add something else here? I feel like this is a football game and you're the play-by-play and I'm doing color commentary or something. Is that
That's
right?
fine.
Okay. Always wanted to do that. So people get really freaked out about minutes. And what I've said, and with sometimes with good cause. I mean, we had a FOIA case once where the minutes were filed on day, I think it was like 8, maybe it was 9, instead of 7, and we had to deal with that. And then you say to the chair, you got to file the minutes, and they say, oh, so time consuming, I can't do it. It doesn't have to be, as Nick just said, you can set up the form on your computer. And when the meeting is finished, just take literally 10 minutes, fill it out, just what he said, the items, the people, the votes, et cetera, the date and all that. And it sends and it goes to the town clerk. As one example, but you can manage it that way and fulfill the law and not get too worked up over it. It can be very simple, but you do have to do it, and you do have to do it within 7 days.
A simple way to do that is to take the agenda and really just convert that into minutes. Just take agenda off its minutes and then just take each of the agenda items and just do a vote was taken, a general discussion was had, and that could be your template because your items are all there anyway.
Right. Create a template like that, and you can do it quickly.
Okay, so we talked about the FOIA requirements before a public meeting, during and after. Let's just briefly talk about executive sessions, which are the non-public portions on a legally protected topic that happens during a public agency meeting. So what happens is the public agency will open its regular meeting, they'll convene in public, and then vote to go into executive session. There's 5 limited circumstances that the Act allows public agencies to go into this non-public executive session. One is for discussion of personnel matters. You hear it framed generally as personnel discussion, but it's really regarding the appointment or employment or termination of a town official or staff person. That's one of the reasons, except if that is the reason that an agency wants to go into executive session, they would need to give that individual that they're discussing the ability to say, you know what, no, I don't want this private, I want this discussion to be had in public. So personnel is a grounds for executive sessions. Pending claims or litigation that the agency or the town's involved in, we can have an executive session to discuss that claim or that lawsuit with, for example, the attorneys handling it. And that would be a private discussion where the members of the public would be removed from the room or removed from the Zoom meeting. Another is for security issues, which think about it in terms of like school security, police security, sure, cyber security, security of town facilities, terrorism type protection. There's grounds to discuss those types of issues in executive session. Another one is to discuss a potential real estate purchase or lease. Because if we think about it, if you're talking about a specific site publicly, that could affect the price. So the law allows for a private, non-public discussion of this potential real estate transaction. And then finally, there's a little bit of a catch-all that says whenever there's a discussion about a record that the next section of the Act says is protected, the record itself does not have to be disclosed to the public if there's ever a request, then that protected record could be discussed in executive session. I say that's a little tricky because that gets a little bit more nuanced. And we don't use it too often, but as an example, and I'll touch on what public records aren't disclosable in just a minute. But as an example, this last sort of catch-all in terms of executive sessions, if we as the town attorneys wrote a confidential attorney-client privilege legal memo to the public agency on a question that was posed to us or regarding some sort of initiative that they want to bring forward, and we're giving a legal advice, legal evaluation. That attorney-client privilege communication under the next section of the Act is protected against public disclosure. So if Ira and I wrote a legal memo to you as a public agency, and the agency wanted to discuss that confidential protected memo with the attorneys in a non-public setting, then that would be an opportunity to do so in executive session. Okay, just to wrap on executive sessions, where you're going to have an executive session, the agenda has to identify right on there, executive session for, and then list out one of those 5 reasons that you see on the slide here. And we want to get as specific as possible, and the FOIA Commission has said, even though executive sessions are private, when it comes to identifying them on the agenda, you still want to be pretty specific to some extent. The best example is with pending litigation. So let's say an agency wants to go into executive session to discuss a pending lawsuit that either they're bringing or that has been brought against them. The Act says you need to identify the name of that case and that court docket. You can't just say executive session to discuss pending litigation, because then the public has no idea what this pending claim or litigation is. You don't have to get into the specifics and the substance of it, but you at least have to identify, what the topic is. But there's some common sense to be used with that too. So think about the executive session for the real estate transaction. You don't have to get so specific to identify the actual property address, because that defeats the whole purpose, right? So it takes a little bit of, again, a lot of this is on a case-by-case basis. The answer for one situation might be different for another one.
Nor do you disclose the name of the person you're evaluating. You wouldn't say executive session to evaluate job performance of, of Mimi Tit. You would not,
Right.
You would not do that. You would just say, to evaluate personnel. One or two other points on executive session. There's a very simple rule, which is basically what goes on in executive session stays in executive session. It is entirely confidential. And you may say to me, of course, why do I have to say that? I say that because, unfortunately, we've had this experience even fairly recently in other towns, where we had good cause to believe that it was not kept confidential, and that just breaks down the system. And then the next question is, well, what do we do? Because we know somebody on the board open their mouth and disclose something, and what can be done about that person? And that's tough, because in many cases they're elected, and what are you going to do? What it does is that it breaks down the work of that commission. They can't go into executive session at that point. They can't do their business in the normal manner that the law allows, because somebody is not keeping it confidential. And so they won't go into executive session. And that makes doing the work of the town very difficult. So it's a terrible thing to do, but it has happened.
I have a question.
Yeah.
If your commission goes into executive session to protect private information about clients that you're working with, not in a commercial, the housing authority. So you go into executive session to talk about tenants who are having trouble paying their rent and what is being done.
So the question, that doesn't fall into one of these 5 categories, but we certainly don't want that out there in the public domain. What reason do we put on the executive session for reason of to justify going into executive session?
Yeah, that's tricky. Maybe that has to go under, there's documents that are confidential and you're discussing confidential documents kind of theory.
Yeah, there might be,
Like you having financial information or.
so that may, I mean, we can talk more offline, but that may fall under that broader catch-all category that I was describing, which triggers, like I keep saying, the next section of the act, which has over 20 different categories of protected public records. So the income information, I don't know off the top of my head. The legislature keeps adding in new categories every year, I feel like. So that might be, the legitimate grounds for it, but it would take a little bit of thought on what exemption that would fall under.
Can I ask this for a second? HIPAA is now being applied widely to just about anything outside of healthcare. Wouldn't that question be addressed with HIPAA? But because of HIPAA, they have to go to executive session?
Not necessarily, because HIPAA only applies to certain entities. And in this context, I've had HIPAA situations where HIPAA has not protected certain medical records that a public agency, specifically a police department, has had. So I'm not sure if HIPAA is the end all be all answer to that question.
There's a lot of tricky stuff, and those are 2 examples that, sometimes we just really have to sit down and think it through. It gets kind of tricky. Yeah.
But if executive session is decided during the meeting, like it's not on the agenda specifically, or if it's just worded, executive session is possible, is that okay to do? And are they allowed to go into executive session even if it wasn't planned or necessarily specified on the agenda what they were going to discuss?
Well, I would say, I mean, I've seen that, executive session for end if necessary.
Right.
And what does that mean? I mean, someone can say, I don't know what that means. What's the topic? Is it litigation? Is it real estate? Is it person? I mean, what's going on? So it could be subject to some criticism, but it's done. You can add an executive session to the agenda if it's a regular meeting. That's another way to do it.
And you can add at any time during the meeting. It doesn't have to be at the very beginning. Could you be halfway through the meeting and say, you know what? I vote 2/3 of the vote to add an executive session?
You could.
You could, we'll say legally. I
Yeah.
think it raises eyebrows if all of a sudden, all right, let's have an executive session and they kick everybody out of the room. You wonder like, well, what happened here? So I don't know if it's a good way to conduct the town's business. It doesn't sound like it's illegal.
But I think where she's coming from, she's police commission, right? And things come up, right?
Right.
Police commission, all of a sudden it's like, well, we need to go into executive session on that one, so.
Oh, on a particular topic, you mean that's on the agenda already or something? Yeah.
Either or, one of the commissioners has something on their mind that they want to discuss, but it shouldn't be open in public session.
Well, you can add to an agenda, you can add
For
executives.
a regular
at-
meeting.
At regular meetings, yeah. And you can add an executive session, so I think it can be done legally. Quick comment, because we'll keep moving here, on the pending claims and litigation, because this is another one that comes up a lot. There are a lot of executive sessions for pending claims and litigation. The easy one is the one, Nick was referencing about putting the name in the case. If it's filed in Superior Court already, you just say executive session to talk about, Bloom versus Town of New Canaan, and that's a filed case. And in fact, you have to put the name of the case if it's pending in court. The trickier one is what is the pending claim? If the town gets a letter, the agency gets a letter saying, if you don't do A, B, and C, then I intend to file litigation next week. Well, that'll get you into executive session because that person has made it clear that that's where you're heading. If the town is bringing the litigation, a tax foreclosure, for instance, you can do that even though it's not filed yet. But sometimes, you get a threatening letter and you say, well, I don't know, is that going to be litigation or is it just, some crazy lawyer writing to us? And you got to sort of figure out, and those are gray areas. So we take them one case at a time and try to evaluate if it's a pending claim or litigation, and sometimes it gets a little nuanced. Is that a fair summary of that?
Yeah,
Yeah.
agreed.
Quick question, does an agenda setting meeting need to be noticed?
What's
I'm
an
sorry?
agenda setting meeting?
Meeting of the executive committee to put together the agenda for the upcoming. Of those things on the administrative level that needs to be noticed when you're not discussing anything specific other than what's going to be for the next week.
Well, I mean, is that like a subcommittee? That's,
No,
the
it's-
executive board.
It's executive board to
We've
decide, are we
never
gonna
done
talk
it
this week,
before.
are we gonna put this on the agenda this week, or are we gonna move it to next week? It's
It's
just
administrative.
yeah, that
Yeah,
sounds,
it's administrative, it's not, they're not talking about
yeah,
this.
okay, no, that sounds fine. That sounds fine.
All right,
One question.
Yeah.
and real quick, hopefully this is a easy softball. Once the minutes are ratified by the committee, can and should the recording of the meeting be erased or eliminated?
no. If it's a fully remote recording, the town has to maintain that recording forever. If I was going to say also, yes, if you're a land use board or commission, because those need to be maintained for the potential for appeal down the road, and that becomes part of a court record. But then that would, otherwise that would, so there's,
Once the minutes have been ratified by the commission, that any recording of the meeting, once the minutes have been ratified by the commission, if this is what occurred, that any recording of the meeting could be erased at that point. And you're saying that?
my
don't
answer
think
is
so.
no for fully remote recorded meetings, and no if you're a land use board or commission. Otherwise, there's a thing that we're not talking about here because, believe it or not, this does not fall under the umbrella of FOIA, but records retention is another question that the state librarian has been charged with. And they're really competent, actually. They're great at the state librarian's office and very helpful if anyone ever has these questions. But they have these schedules that identifies basically any category of record that you might encounter in your role serving the town. And it identifies how long we're obligated to maintain those before we delete them. So I would.
There's a mostly non-legal answer to that also, which is there's some public policy value in saving those, if you're talking about a video or even audio recordings. The days of verbatim kind of minutes are rapidly going, not completely, but pretty far gone. And many times, for whatever reason, just to see what the origin of something is, or maybe it has legal reasons, you want to look back and see what the town council did, in 1984. You would look for minutes perhaps back then and all that. So for that reason, I think there's value in keeping those recordings.
But if you do find
Indefinitely.
yourself in executive session, you don't take minutes in executive session, you don't take.
Yeah,
any
that's,
votes.
that's
Yeah,
a good,
yeah.
that's a given.
Yeah, so that I was just gonna wrap on that for executive sessions, the biggies there. Thank you, Tucker. No votes are taken in executive session, only discussion. If there's any votes, those can only be made in open public session. And like Tucker just said, no minutes taken during executive session. The main meeting minutes only need to reflect who goes into executive session, what time, that there was in fact a vote to go into executive session, and then same for when everyone exited executive session. That's all that gets.
Come out of executive session is out of executive sessions. You're not voting in executive session to come out of executive. session.
That's right. Okay, and then it just,
Ever on running a remote meeting on executive session, make sure to pause the recording on video.
You know, I just want to clarify that, so, because another board I was on, we had very specific, different ways of doing this. So we voted to go into executive session, it was denoted who voted to go in and at what time. So it was who voted, who came in, who seconded, every person who voted, I mean, we kept track of everyone. And then when we came out, there was a vote time that in executive session that we voted to come out of executive session. And then obviously time. And so, and the vote was recorded. So technically you're in executive session when you come to vote to come out. And so we denoted the time, who voted and seconded and everyone that voted. And then obviously you voted to.
That's always been confusing for me.
I think
We
that,
have very clear minutes that way, and so it's very different than we do it on the town side, so. And I don't know if we were just being over and above and super careful, but they're very different.
I've had many lawyers say to me, you do not vote to go out of executive session.
You just.
But I still, I hear it done all the time and I don't stop it. I just say, okay, you're gonna vote to go out of executive session because it seems logical you voted to go in, but you're not supposed to vote in executive session.
Confusing part.
So
Yeah,
I've had lawyers said to me, and I never really tried to pin it down. Do you know the answer?
I mean, I think,
I'll put it on the spot.
no, it is what Ira's saying. I mean,
Lawyers have said to me, you don't vote to go out of executive.
it's
session.
not a legally
We can check that.
effective vote. I mean, it happens and it's a decision to exit executive session, and that's just the mechanism that it's been done.
Satisfactory for everyone to say, are we all good to go out of executive
That-
session?
I think so.
That's what, I think
Yeah.
that's what, I think that's accurate, but
Then you.
intuitively, one more comment, since you mentioned videos, here's a little tip. And this has happened to me and to many others, but especially in the land use context, you have to be careful. You know, that there's a recording and then you finish the hearing, you finish the meeting, you've completed all the public hearings, everybody's putting their papers together and then there's some chit chat here, or the town attorney comes up, as I once did. And, or someone from the public comes up and they say, well, that guy testified, what a jerk. And that's on the tape, on the video. And it's been thrown back in the lawsuit too. I had that once. So the lesson is really don't have that kind of informal talk right after the meeting.
And the meetings, if you're the one running the meeting, as soon as the meeting's over,
Turn it off,
meeting's over.
make sure it's turned off. If you're a member of the board or commission, don't lean over and say, didn't never like that guy from day one, because that'll come back to bite you.
And Tucker can probably speak to this better than anyone, but the only other sort of tech tip I'll give in terms of executive sessions is if there's a hybrid or remote component, so meaning there's members of the public attending remotely, how do you get them out to hold the executive session?
Usually put them all in the waiver. And then at the end, you can knit them all, so you just leave whoever's staying in, but you have to one by one. And the important thing to know about that is while you're doing that, you have to tell them, don't start. We're not in executive session yet. Wait till I tell you that everybody is out of the room because, and the recording is paused.
All right, so we spent an hour and 20 minutes talking about the public meetings, this very important aspect of the act. The other piece of this is public records and FOIA requests, which everyone should just be aware of. This is something that you're all as town board and commission members subject to. And really what the act requires in this sense is that the town provides the public with access to its records. Under the act, a lot of records, not all, but many of them are available to the public upon written request. It can't just be a verbal. The law says if you get a written request for a type of record, we're obligated to produce those records unless they fall under any of these categories that are protected. For any records that are not protected from disclosure, the act says we need to compile those records and produce those to the requester promptly. That's the word that's used. It's a relative term. People get all caught up on that word. They look at the act. They say, well, it says 4 days there. Doesn't that mean if I don't get all my records in 4 days, then I could file a complaint with the commission? No, that is not what that means. It gets a little nuanced in the case law, but really we recommend within 4 days of receiving a request, acknowledge it. Tell the requester or whoever you're working with staff, acknowledge the request to the person who made it. Say, hey, we received your request. We're working on it. We'll get back in touch with you soon. At the very least, because the FOIA commission really does not like it if an agency just ignores somebody who makes a request or says, yeah, we're working on it, and then goes completely radio silent for the next 4 months. That does not mean promptly. But promptly means, I said, relative. The act, the legislature recognizes that we all, I mean, a lot of you volunteer board and commission members not only have day jobs, but your volunteer roles here as well. So the time and effort that is required to promptly compile and produce these records, if you're ever subject to a request, it's a balance with your day-to-day life. It doesn't go magically to the top of your to-do list for every aspect of your life and career. But you should put some reasonable effort as you can into as promptly as possible responding to these requests.
I just.
Yes, Mimi's the
Oh,
expert
yes,
here.
yes.
Please.
Well, guys.
Just on the town side, if you personally get a FOIA request, I would appreciate it if you would forward it to me, mimi.pitt@newcanaanct.gov, because we try to keep a handle on all the requests coming in, the timing and all of that. And there's a good chance I can help you reviewing email and stuff like that. So don't feel like you're in it alone, I guess is what I'm saying. And definitely pass it on so that we know it's happening.
And Mimi is being extraordinarily humble right now, but
So-
I mean, we use Mimi as our example with some of our other towns as like what, you know, really it's ideal to, and Mimi's an attorney as well. I mean, she, amongst the many things that Mimi does, just what she said, she has overseen and assisted our departments, our staffers, our board and commission members when they've received this type of request, and importantly, kept a really good record of these steps that have been taken to respond to the request. Because if some disgruntled requester down the road, and this is what we do all the time, files a complaint with Hartford, it's hugely persuasive to come in, and I put Mimi on the stand and we go through the whole timeline. Okay, the request came in on this date, we responded right away, we started compiling records. That is a huge asset to have, and it's helpful whenever any of the towns have some sort of internal protocol for processing these. So yes.
I'm new to this, and so my question was gonna be, how often does it come to an individual? Like, do they not usually come through the town?
So sometimes it goes directly to individual. It depends on the topic of conversation. It might just go to an individual. It might go to the town, however that might be, whether it's an email to a general email account or what. But what the act actually says is the agency that receives the request. That's the only agency that technically under the law is responsible for responding to it. So what I mean by that is if the P&Z department, somebody files a request to the P&Z department for all grant applications that the finance department has filed, the P&Z department now doesn't have to forward that request to finance, number one, nor does P&Z have any obligation to respond because it probably doesn't have any grant application. So, I mean, that's technically what the law says. The public agency that receives the request is responsible for responding, and if they don't have any documents, then there's no responsive documents in response to that request. But the answer is yes. I mean, there's been plenty of instances where individual board and commission members with a contentious issue in town have received personally a FOIA request for records related to that issue. And that's where it's really instrumental to use someone like a Mimi for help.
And a FOIA request can look in all different shapes and forms. I mean, we had someone come in the other day who just literally wrote on a little piece of paper like this, I'd like to see this, and handed it to us.
It doesn't have to have FOIA
Right.
in it.
So it was literally a scrap piece of paper.
Mimi, can you go to the next slide, actually? While we're on this, I'll just, so if you get a request, though, you don't have to conduct research. Like, you don't have to come up with an answer. You don't have to answer questions. You don't need to create documents. You don't need to reformat documents. What the act says is if you get a request for these public records, you're only responsible for giving an actual record that exists as of the date you received that request. And you don't have to go above and beyond. You don't have to answer questions. It's really providing documents that exist.
Can I just, for 1 minute, I just want to underline the value and importance that in having Mimi here to assist all of us. It is just a tremendous resource that other towns do not have. So we're very fortunate in New Canaan to have her here, to the point where I have said to at least 4 other towns or 5 in these words. I've said to the other towns, you need a Mimi pit. And to which they have said,
We know.
well, first they say, who? Or what? But I explained to it. And so I have actually said that with using your name, a person who understands the law and can help out the volunteers and the paid employees too. And it's just a tremendous value.
Can I ask a question to follow up on that though? It's pretty obvious what you put up here. I'm a town council member and I've taken a lot of notes at a meeting. Someone from the press or somebody saw me taking all those notes. Now they want to see my notes.
Mhm.
My personal diary notes.
So we didn't plan this before, but that's a great segue into the next quick little thing. All right, so we've talked about what records are protected. Okay, and one of these categories, Mimi, do you want to know what is the next slide? All right, so this talks about, it's an actual document. It's an actual record that exists. These include, in today's world, emails are the bulk of records. When we get a records request, it's mostly emails and attachments to the emails. But it also includes any physical hard files that you as an agency member might have in your possession. It also is, like we said, text messages, voicemails. These fall under the definition of public record. But the legislature, Mimi, what's the next slide? Okay. When they passed the act, I've said it a few times now tonight, they created protected classes of these public records. There's 28, I guess, the last time I checked. They get pretty complicated and nuanced, and those are for side discussions with us and or Mimi if you ever encounter them. But things like I discussed before, the attorney-client privileged communications. So if you had, for example, email communications with Ira or I, where we were actually giving some sort of legal advice, or you were asking for some sort of legal advice, or the communication was related to the giving or receiving of legal advice, that's a protected communication that if you received a FOIA request on XYZ topic, and these emails with the lawyers were responsive, those would be protected, and those do not have to be disclosed to the person who requested. They can be, but they don't have to be. And I'll just add to that, just CCing the lawyers on an email does not automatically create the attorney-client privilege.
Even worse, I've had people say to me, high-level municipal people say, well, I'll tell you what, I'm not gonna send it directly to Tucker. I'm gonna send it to you, Ira or Nick, and you send it to her. I don't know what that's about, but I don't think that makes it privileged, but that's what people think. Anything that has our CC on it or a name on it, that's not necessarily privileged. Has to be some confidential, some advice. So keep that in mind.
So the next one, I'm not going to talk about all 28 of these, but just to make a couple of the big ones. Tucker just alluded to this. So someone's taking notes during a public meeting. A member of the public or a member of the media says, hey, can I have a copy of that? There is a class of protected records, drafts and notes. So if there is a draft document that has not yet been acted upon or submitted to the agency that's going to be reviewing or making some sort of comment on this draft, that is protected from disclosure. It's not a final document that the agency has ratified, for lack of a better term. Notes also, these handwritten notes falls into that same category. And the act and the commission has held, they do not want to have a chilling effect against people taking notes during these meetings. I mean, it's pretty helpful for some of us. So, so that's supported in the law that those types of notes are in fact protected. But if someone that protection could be waived as well. So if someone starts giving out their notes to some people, then and a member of the public makes an official, hey, I want a FOIA request for that record. Has that person waived this privilege now? Arguably, yes. So,
And in that vein, if you're looking at a document that had been a draft at this public meeting table, and you're discussing it in the public, then it's no longer a draft. You are discussing it in public. You've waived that protection. So keep that in mind. Do you want to talk about, balancing with the drafts a little bit? So not everything, just because you stamp a draft, necessarily means it's.
yeah, that's a good point. I mean, we can get it very nuanced with all this stuff, and
But the draft thing comes up a lot.
yeah,
People think that, you put the draft stamp on it, you're good. You don't have to disclose it ever, and that's not the case.
So there's always a but with anything involving the lawyers, right? But so with the drafts one, in order to legally protect a draft under this category, it can't, like I just said, you can't just call it a draft. The second piece of this is there has to be a balancing by the agency in charge of that draft. Where does the scale tip? Does the scale tip in favor of public disclosure, or does it tip in favor of withholding? And that's really a judgment call that depends on the effect that disclosing this draft might have if it's released to the public. Because sometimes we release a draft and it's really a rough draft and things change a lot after that draft. And if the public gets a copy of the draft beforehand, but we've seen it before, it misleads things, it gets people all worked up when maybe it's a moot point. So that's what's built into the act. It says, okay, if it's really something that should be withheld at this point, and the public agency makes that call, but that's a call that has to be made before you say, no, I'm not going to produce a draft. And we've got caught on that before where the commission has said, well, who did the balancing test? And what was that discussion like before, not after? And it's something that has to occur, this balancing. The other categories I'm not going to talk about, the police have a whole bunch of law enforcement and investigative records that are protected. There's specific classes and categories of people like public defenders, like judges, police officers whose home addresses are protected. So point being, there's 28 or more different categories of protected public records that would not be subject to disclosure after a request. That's really it for me. Mimi is great. Take advantage of her. And we are here for questions.
I just want to tell you from where I sit, in my role as administrative officer, the places where I see people getting into the most trouble are the emails. People can think, oh, I'm just emailing you, and then the discussion happens. And that's the biggest red flag that I can warn you on. Just really try to refrain from the emails if you can. The only question I have about that is, if I'm the chairman of a commission and someone emails me and someone else emails me, I can push information out as long as there's no discussion, right? I can say, well, certainly a logistics, we're all going to be meeting at 7 o'clock, see you tomorrow night kind of thing. But is there a way to communicate through the chair without it being a meeting?
Not really.
Yeah.
So the emails is a big problem, and then the meetings. In fact, something came up tonight that was very interesting. The Conservation Commission was meeting at 6:30. I was having all sorts of tech glitches with them. They had a remote, hybrid option on their agenda. We couldn't get the computer to work. They said, don't worry about it, Tucker. No one ever attends our meetings. And I said, that's not okay, because we have told people that that's available. And if one person tried to get on that meeting, I mean, we just said, no one's there. That meeting, everything that happened in that meeting would have been for naught. So I almost told them they weren't going to be able to have their meeting, so I was able to get it up and running for them. So it just, sometimes it seems so obvious, it seems like the depth of common sense, but it's very tricky. There's a lot of areas we get called up.
One more brief comment on emails, the content of emails. Be very careful about what you say in an email. There's a tendency sometimes among people who work together to be casual or jokes or, even comments, about people and whatever. And if they're disclosed, it's going to work against you, and someone could misinterpret it, and that could influence an outcome of something or just cause hurt feelings or whatever. So I like to tell people jokes don't translate in emails, and any sort of casual kind of stuff can give the wrong impression. So I would keep it, all business as much as you can. When
Write
you're
an email like you think someone's going to be reading it.
That's what
Yeah.
I was going to say.
write it, write it as if the public's going to read it.
I have a question about, just again, new to all this and trying to do all town business on only town email, but like in my personal email, like, just like, that's housekeeping thing, like extraneous things I tend to delete. I don't like to have just thousands of them, to go through. What's the policy? What's the thought on deleting, like, emails of like, are people free to meet on Tuesday the 20th? Like,
Your town emails?
yes.
There's she's got a current record of them, even if you delete them.
Okay.
She's got them.
Right. I got them.
So even if you've deleted them, she's can go back. Yeah, she's got software that can go into anybody. You told me, I don't know if this is true, but I believe you, that there are some communities where emails are open to the public at all times.
Yes, yeah, so we
Someone
haven't gone
can
that
go in
route yet.
Yeah.
But questions, for those of us with personal, with town devices, but obviously we have phones too, we have personal, we don't have a town phone, we have a personal phone. Can we text to town council members?
I would totally avoid texting if you
Okay.
can, honestly, they're so hard to reproduce if you have to.
Even within a caucus, like if you're just.
It's just not good practice. I just,
to stop.
best thing you do is pick up the phone, pick up. the
Yeah.
phone.
Oh, okay, so wait, just to clarify, so better call someone and get off any kind of text chain on your phone, okay?
I mean, the point is that text change would be a a public record, that if someone makes a request, then Mimi's gonna have to work with you to take screenshots of, A, remember that you have those texts, B, find them, take screenshots, somehow get them to the person. And if then that type of request is made, and let's say you were having those text messages, conversations with your fellow board members, then you're giving this requester essentially proof that, well, there was kind of an illegal meeting going on here. There's these communications to a quorum, this back and forth, that really, under the act, is a public meeting. So that's
Those are foilable.
Yes.
for town business. Whatever town,
Members of boards use their personal computers for periods of time while those pieces of information are extracted from their personal computers.
Yep.
So you really don't want to use your personal.
Yeah.
computer.
Answering machine, that's good to know.
If you don't use it, and you. and
Yes, and
someone-
if you don't ever use it for government business, then they can't take it.
So they tried it and you say, I don't have.
You can say I have nothing.
Yeah,
You
you
can
can
say,
say
you
that.
look and you say I have nothing, you're fine. But you better have nothing. Because if someone else doesn't and turns it in and yours is on there and you said you can write. But certainly it's okay to say, I'm gonna be late tonight to the chair, I'm gonna walk in at 7:02. Or it's snowing, I'm gonna be remote. It's just the business. We're here to help as much as we can. We're not experts, we go to them a lot.
If you're a member of a board or commission and the paper FOIA's any communication between you and another citizen that's not part of, is that FOIAable?
well, you as a member of the town council, because you're a public official now, that email communication from you, I mean, if it's related to town business, that's a public record.
No, there was none in this case whatsoever, but if the media comes and asks me to disclose any communication between you and a private citizen, and there is no question as to, because at meeting A, they had this conversation, or there's any record of anything. Is anyone from the public, just because they have a conversation with a public official, FOIAble in terms of that communication? It could be that, that person's child got married, and I congratulate them.
Well, that's not town business.
Right.
Exactly.
That's not town business.
But how do you handle fishing expedition by the media to disclose and create a FOIA request when they're not specific? How specific does that FOIA request need to be in order to be valid?
Well, you need to know what they're looking for. However, the act doesn't say, it doesn't say, well, you have to be. The act allows requesters to make these very broad requests, which are any communications related to you name this topic.
But sometimes it's, they don't, or they give you, a word search and say, I want all communications that have the word water in it. Well, that's a real one.
Yeah.
All right, well, can you narrow it down? No, I don't want to.
Mimi's pretty good at working with them and saying, is there a date range? Is there a word? Could you give me a little bit more of an idea? It just makes her, we're paying Mimi by the hour to do all this for us, and she's quite efficient at it, but she works with everyone, and usually gets somewhere to need to be.
Ultimately, if it's purely personal.
Yeah,
and
I wouldn't disclose your daughter's wedding
Right.
arrangements,
Right.
And that's the other thing, if somebody has FOIA'd for your email, I would let you know that this is going on. I don't just start turning stuff over. I let the people know, that we're involved in this, and it may involve your town email.
But there are, to your point, Christina, it's a good one. There are some people out there that make the FOIA system work for them, and they don't have the best motives, right? And they're just trying to clog things up and make work and all of that, and we've had a few cases of that over the years.
Hence we hire Mimi.
Right. But it is a problem because we can get wrapped up in it all day, every day. So best advice is just, really keep that email to business. I have a question. How often are you doing something?
We get on average 75 to 100 FOIA requests a year.
Yeah, but some requests can be,
And a lot of them are very big. Some of them are not. Some of them might be one-off things. I think, sometimes departments handle those by themselves and I don't even get in the middle of that. But we,
and that doesn't include all of that.
we've had a few years where we've been very busy with it, so.
More than a few.
And Board of Ed handles their own, police handles their own.
Thank you.
Yeah.
Thank you.
Okay.
Yeah.
You're very welcome.
Great. Thank you all for coming.
Thanks, guys.
Yes, man.
Thank you.
We had,